All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Nous sommes en audience publique, Monsieur le Président.
We are in public session, Your Honor.
Much. The Chamber will deliver its ruling on the motion argued earlier this morning. The defense made a request for disclosure of, first, all costs expended by the Victims and Witnesses Unit for purposes of relocation, maintenance, and or support of Witness 268 within the Witness Protection and Support Program. That is the first limb of the defense request. The second limb of the request is the disclosure of any evidence tending to show fraud or rather acts of illegality on the part of the witness that bears a direct connection to his maintenance and support within the Witness Protection and Support Program. The legal basis of the defense request are alternatively the Chamber's decision of the 4th of September 2013 entitled Decision on Disclosure of Information related to prosecution intermediaries, or alternatively Article 67(2), which requires the prosecutor to disclose information which may affect the credibility of prosecution evidence. The rational basis for the request, of course, is that the request may affect the credibility of the witness. The OTP does not oppose the second limb of the request, but they do oppose the first limb of the request. So too, as we understand it, does the VWU. The reason for opposing the request is that the VWU is an independent unit tasked with making independent judgment on what is appropriate in terms of costs to be expended on witnesses' sustenance or maintenance, witnesses that are within their care. And as such, all efforts are made to ensure that those costs are reasonable and not inordinate. The Chamber grants the request in part only, and only as regards the second limb of the request. The Chamber denies the request in all other respects, in particular as regards the first limb of the request. In the Chamber's view, the probative value of granting the request in the first limb is outweighed by both the considerations of prejudice and efficiency, not only in relation to the witness, but also the operations of the Victims and Witnesses Unit and the administration of justice in general. Witnesses who come to testify, it is presumed, will have to have sustenance in their lives, whether it is afforded to them on their own or through the instrumentality of the Victims and Witnesses Unit. It therefore does not afford a prima facie indicia of credibility that the Victims and Witnesses Unit has undertaken those reasonable tasks of providing reasonable support and maintenance to a witness rather than the witness doing it themselves. That is the ruling of the chamber.
As the court pleases, Your Honours. I know that Your Honour is anxious to get started with the next witness, and I understand he is ready to come. If I may just raise one matter, and perhaps Your Honours can give us an answer in due course, and that's simply relating to the conduct of proceedings. Now, we've lost some time this morning, more time on Friday, and again this afternoon. The result being that in the assessment of the prosecution, at least, it is unlikely that we will be able to finish both of the witnesses who are presently in The Hague by the end of the week as planned. So my first request is for an indication as to whether or not, if we do not finish that witness, if we will be able to continue into the next week to finish that witness before we break. The second one, which I imagine Your Honours will not be able to give an answer as readily, relates to the conduct proceedings thereafter. I did raise this issue a few days ago, Your Honours, but in the interim, I note that the defence in the Kenya 2 case have filed a request for an adjournment of that matter. Now, obviously, we cannot prejudge what will happen with that request, but if Your Honours would be predisposed to guide the parties as to what would happen should that request be granted, so that the necessary plans can be put in place to secure witnesses. As Your Honours know, there is approximately a 2-week lag time to get witnesses who are based in Africa or overseas to the court to testify. So there's some considerable logistical issues that will need to be addressed.
Thank you very much.
Mr. President, 2 matters with your leave. The first, if the court officer, with your permission, can give me some assistance. The microphone and audio system on this table is not working in the middle and on my side, so I can't hear the translation. So if somebody could come and fix one of these 2 devices, I'd be most grateful. Your Honours, when it comes to the schedule next week, of course we're in the court's hands, but we've been guided by the court schedule at the moment, and we have various team members have other commitments that have been planned because we had been led to believe the session would end on the 1st of November. Your Honours, from what I understand, and my learned friend Mr. Hooper QC and my learned friend Mr. Katwa Keegan, as well as the prosecution, no doubt, could speak to it. We anticipate this witness will take the bulk of this week. And it may well be, in those circumstances, the more prudent course would be to release the witness to come back later, because, of course, there is the option of starting maybe on Friday sometime, a bit of examination in chief. But on balance, my own personal view and my own submission would be, where possible, it's always preferable to keep examination in chief and cross-examination together, unless it's absolutely unavoidable. So my submission would be the witness could be returned and no need to keep the witness unnecessarily in The Hague until the current witness is finished.
Your point is that beyond the 1st of November, you have other commitments you've made in the meantime that may not allow you to continue beyond
Yes, Your Honour, of
that.
course, we will endeavour to accommodate and comply with whatever directions of the court, but we have planned certain, amongst both teams, I think we can speak for both teams here, certain discrete investigative activity and other activity as well that would put us in hardship. Your Honour, in relation to the second aspect and the court calendar, Your Honour, that's a matter that the court will decide in due course, but for my part, on behalf of Mr. Ruto, the court have been well informed about our preparedness to start this case and the need, our original request, based upon the judgment of all counsel involved, that we needed until November. Now, Your Honours, complying with the court's order, as we have, we factored in that during certain breaks, various very necessary investigative activity would be carried out. And so actually we need those court adjournments to do essential jobs that actually should have been done before trial started but haven't. So Your Honour, I'd ask that to be borne in mind. It's not a question of simply, of course, filling the slots because something may or may not happen.
Why don't we not, let's proceed this way. The prosecutor has raised this matter and put it on the table, and he did not require a ruling immediately.
Okay.
Why don't we, as it were, put it on the bring up matter so that we can later on bring up that matter,
So be it.
especially in light of the application I understand has been made in the companion case
Indeed.
for an adjournment. So if that is resolved either way, we may have to take up what happens with our own case in here.
I'm grateful. We'll be so guided.
Why don't we do that and then proceed with calling this witness? Yes, we have lost some time discussing necessary procedural issues that we need to take care of.
Mr. President, I just wanted to be sure that you will hear me before any decision is made on that issue of extending the time.
We're not making any decision.
Most
That's what I'm saying.
Thank you, Mr. President.
Can we bring the witness in now? Blinds down and the witness called in, please.
Nous sommes en audience publique, Monsieur le Président.
The court officer, we are in public session, Your Honor.
Thank you very much. Witness, welcome to the courtroom, and thank you for joining us. Your oath will now be administered to you. Court officer, can you kindly administer the oath or the declaration?
I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you very much. What you just declared is, in a nutshell, all that we require of you for your period of stay with us in this case. Just to speak the truth, the whole truth, and nothing but the truth. If you do that, you would have helped us a lot in our work. And doing that requires the simple matter of really listening closely to the questions the lawyers would ask you while you're in court. The prosecutor would begin asking you the questions, and after they're done, the defense lawyers for Mr. Ruto and possibly also Mr. Sang will have the right to ask you questions also. As they do that, just listen carefully, make sure you understand the questions they're asking, and after you've understood each question, then you do your best to answer it truthfully, to the best of your ability. What we require of you, what we're more interested in, or most interested in, is what you witnessed yourself firsthand, what you saw yourself, what you heard, what you smelled. Essentially, firsthand experience from you is what we're interested in. Try not to guess at answers. Try not to draw inferences if you can avoid it. Inferences as in there's one fact and another fact, and then you come to your own mind that because there's one fact and a second fact, it necessarily means that a third fact also is the case. Try not to do that. It is the lawyers who will do that at the end of the day. Just concentrate on what you saw and experienced or heard. Try not to guess also. If you do not understand the question, tell them you do not understand the question. If you do not have an answer, tell them you do not have an answer, you don't know the answer to that question. That's all right too. Try not to guess if you can avoid it. There is another matter that's very practical, and that is the matter of we want to make sure that your trip here is worth it, so that what you are telling the court is actually heard correctly and recorded properly. That requires you to pay attention to the work of the interpreters up there and the court reporters. They will help to interpret what you say into different languages of the court, and also to record your answers for the transcript. You need to assist them in doing that work by speaking slowly, not too slowly, but don't speak too fast. Also speak in chunks of information and not to give continuous flow of information that may take up to 10 sentences continuously. Speak deliberately, stop, so that they can digest what you're saying and capture it properly and record it. There's something we call the gap rule. The gap rule also assists in making sure that your answer is captured correctly. That is a gap that must be observed between the speaker asking you the question, between when he finishes asking the question and when you start answering it. There's a little gap that needs to be observed. We call it the 5 seconds rule. It also helps interpreters and court reporters to do their work. If you observed all these things, you would have assisted us a lot in our work. And again, I thank you for coming to give us what you know.
Mr. welcome, Your Honor.
Thank you.
Your Honors, just before we do start, just a matter of procedure, there is a question of bundles that the prosecution had prepared for this witness, which contained the annexes of the statement of the witness's statements, and other prior statements as well. Before we started today's hearing, Defense Counsel Mr. Hooper indicated that he strongly objected to a lot of these documents being in the bundle that was going to be provided to the chamber. Obviously, the prosecution has no problem with removing the documents that are deemed problematic by Mr. Hooper, but obviously we'd like the chamber's guidance on this matter, because the fundamental reason why the prosecution inserted these documents is so that the chamber could possibly refer to them, ease of usage, during the examination or cross-examination of the witness. So I leave that obviously in the hands of the chamber. If need be, we have the bundles right here. We've recuperated them. We can either provide the chamber with an amended one with simply the annexes of the witness, or one with all the documents, depending on what the chamber requests.
The matter would be, the objection, Mr. Hooper, would be as to statement, you said?
Well, essentially what I objected to were documents which in the normal course of events would not be admissible in chief. And when I raised that with my friend, he said he'd put them in, I thought, over kindly, because they might be documents I'd want to refer to. But of course, if I want to refer to documents, I'll put them in my own bundle and provide that to the judges in due course. So I'd submit that this is the better and more appropriate position.
But the bundles are not evidence. They're just handy package of information that may be useful. They're not being admitted. I can assure you that in previous instances, I have not looked at witness statements before coming here. But in the course of the arguments or the witness testimony, when the questions are raised as to what they said, then we look at them at that time. That's how I've done it.
Well, I've raised no objection to the statement going in, because we learnt last week that that was the position, that John has access to them and refers to them. So I didn't object to that. I objected to other documents which, so far as I can see, would not be properly admissible in the course of an examination in chief of a witness, one's own witness. I thought it was quite inappropriate that those documents would be put in at this stage. If in the course of the trial those documents become relevant, they will, I would anticipate, become relevant only in cross-examination, in which case, Your Honour, will be provided with them. But I don't think this is an opportunity for the prosecution to pack its bundle with all manner of statements. And so I suggested there was a line to be drawn, and I hope that's an appropriate one. So the position is at the moment that what Your Honour has here is a bundle that contains the witness's statement to the prosecution, the fundamental statement, and it includes the exhibits, and it includes some other matters which, in the normal course of events, I do anticipate my friend seeks to introduce. May I say that in respect of certainly one of those items, there will be an objection in respect of its admissibility, but it's still in the bundle.
All right, we will, prosecutor can hand up the bundles. What we'll do is Mr. Hooper has already flagged his concerns. At the appropriate time, if the prosecutor makes a move to tender any of these documents, we will hear the objections at that time.
Mr. President, on that issue, may I indicate that I didn't get access to the document?
You did not?
I had not been given. And so I reserve my right to object at that appropriate.
All right, definitely.
Thank you.
All right, why don't we
Your Honors, given the...
get going on this witness's testimony.
I can perhaps start immediately with the witness, but given the objections by Mr. Hooper, we had already removed some of the documents. I understand that we have approximately 55 minutes of testimony today, and most probably we'll only be getting to one of the documents. So for defense counsel, we will provide the full version after today's session. I understand that the chamber has
Are you saying that we have the full version?
Yes, Your Honor. From what I understand, I'm looking at it right now, and I see that that is the full version, yes.
All right.
I just want to make sure with Mr. Rojas whether these documents have tabs A and tabs F on them, in them still incorporated.
The tabs are still there, just not the contents.
Yeah.
There is nothing in tab A, and there is nothing in tab F of my own bundle.
What we can do, Your Honor, is we'll supplement and add those after today's hearing. That's not a problem.
Okay, please proceed.
I'd like to request that we go into a private session, Your Honor.
For how long?
For the first part, it should take 10 to 15 minutes, Your Honor.
All right, private session.
The court officer.
Nous sommes en audience.
The court officer, we are in public session, Your Honor.
Thank you.
Now, Mr. Witness, I'd like for us to start with this whole issue of the 2005 referendum in Kenya. And I'd have some questions to ask you on that subject. Now, could you please tell the court who was president of Kenya at the time of the 2005 referendum?
It was Honorable Mwai Kibaki, Your Honor.
Can you also tell the court, Mr. Witness, of what party he was representing?
He was in NRC coalition.
Now, just for the record, is that NARC, the acronym of the party?
National Alliance Rainbow Coalition.
So just for the record, Your Honors, line 14 should be corrected. It's not ACF Coalition, but NARC. Now, Mr. Witness, can you please tell us what was the atmosphere like in Kenya at that point during the referendum?
The country went into a referendum, and after referendum, the country was very divided.
Now, when you're saying that the country was very divided, can you tell us if the ethnic groups were divided?
There emerged division between Kikuyus and the rest of Kenyan tribes.
Can you tell us briefly what was that issue during the 2005 referendum?
The driving issues during the referendum was power, jostling for power. Number two, there was a land issue at stake also.
Now, were there different movements or parties that were confronted during this 2005 referendum?
Right. There were those who were against the proposed constitution then, and they were represented by orange symbol. And there were those who were for the proposed constitution, and they were represented by banana symbol.
Can you tell the court, Mr. Witness, what politicians were part of the orange movement and those that were part of the banana?
Your Honor, Kibaki was in banana team. Orange team, we had Raila leading it. We had Ruto, Honorable Ruto. We had Uhuru. We had and others.
No, Mr. Witness, just to be clear, when you say Mr. Raila, is that Raila Odinga?
Yes, Your Honor.
And when you're speaking about Mr. Uhuru, is that Mr. Uhuru Kenyatta?
Yes, Your Honor.
And when you spoke about Mr. Ruto, this is Mr. William Ruto. Is that correct?
Yes, Your Honor.
Now, you mentioned before that it was a jostling for power and there was also the land issues. Can you just elaborate for us on this whole question of land and how it was related to the 2005 referendum?
The draft constitution had proposed some policies on land. And it happened so that politicians, as they went around, they talked on this issue of land. And Orange team particularly happened to have rallied people against it in the sense that land was going to be taken away from the masses, if indeed they support the draft constitution.
Thank you for that, Mr. Witness. On this whole question of land, you said that land was going...
Can I just interrupt just for a moment? Of course, it's always of interest to know an individual's viewpoint, but there's been no basis here laid for any expertise or the like in respect of this witness. And I'm wondering in those circumstances what particular relevance this has.
Your Honor, I'm not quite sure I understand that objection, because the witness was there at the relevant time period and is here to explain what he observed, what he saw, and how he understood the referendum. And that's quite relevant, because it is with a certain knowledge of what happened in the referendum that we get to understand what happened afterwards in 2007 during the elections. So he's speaking in his own capacity, and we've never presented him as an expert. And obviously that'll go to the weight of his testimony in the end. And second point, as my learned colleague will see, is that there are other relevant matters that he does speak about as well that are coming up in his testimony at paragraph 17. So it's a lead up to that. I hope that answers my colleague's objections.
Objection is overruled, but keep it, do not spend too much time on this. Let's find a way to cut around it quickly and get to the other points that the witness will need to testify to as well.
I'm grateful, Your Honor. Now, Mr. Witness, when you gave your answer previously, you spoke about the land issues and the masses. Can you just elaborate on that? What ethnic groups were going to be affected by this land issue of the referendum?
As I stated, Your Honor, the battle of the Constitution was between Kikuyus against other tribes, seemingly. And it so happened that land issues is more pronounced when it comes to tribes in the Rift Valley and tribes at the coast province of Kenya.
And when you're saying that the land issue is more pronounced for tribes in the Rift Valley, which tribes are you referring to?
I'm referring to Kalenjins in the Rift Valley and the coastal tribes, of course. There are many coastal tribes. I don't know them.
I understand, Mr. Witness. And if you just give me an additional, I just have one additional question on this. How did the Kalenjin tribe view this proposed referendum or constitutional draft?
The Kalenjins bought into the idea of land, that if indeed we support it.
Mr. President.
Mr. Katwa.
Yes, Mr. President, I would like to raise an objection to that question. As that is seeking an opinion, Mr. President, which I thought is contrary to the injunction you gave right at the outset by telling the witness to testify on what he knows rather than his own deductions of issues. Mr. President, we would object to that.
Objection is overruled. If we are talking about opinion evidence, any witness can give it. It's a matter of degree.
I'm sorry, Mr. Witness, I think that you were cut off in when you were going to respond. My question was, how did the Kalenjins view this land issue?
Land issue is so dear to Kalenjins, and it happens so that politicians have been exploiting it every now and then during elections. Kalenjins love their land, and they cannot allow any idea to the extent that somebody else is going to take over it.
Just if we just come back on that, Mr. Witness, and I'm sorry for that, but you started out your answer by saying land issues, and you also said Kalenjins, that it happens so that politicians have been exploiting it every now and then during elections. What is it about the land issues that you were relating to the Kalenjins?
Kalenjins have a history of dearly protecting their lands. And politicians tend to exploit that issue during any other elections, probably to their advantage.
And how is it that they exploit that to their advantage, politicians?
It so happened, I don't know, it so happened. Every other election, particularly an election that pits major tribes, land issue has to crop up. It has been happening. It didn't happen only during 2005. It has been happening ever since, every other election.
What exactly would politicians say?
Politicians, while looking for faults, would come up with the issue of land in the sense that if you support them, the land will be taken away. So we need us to protect our land.
And just to be clear on that matter, when you're saying if you support them, what ethnic group are you referring to?
Every other election, and particularly during this referendum time, Kikuyus haven't settled in many places in Kenya. Kikuyus living among the Kalenjins were the one to suffer, if in case land issue is exploited by politicians in the Rift Valley.
Just to be clear, you said Kikuyus living among the Kalenjins were the one to serve, and we don't have that on record, if in case land issues is exploited by politicians. What were you saying there?
I think I heard him say suffer. Did you say serve or did you say suffer?
Suffer.
Most grateful, Your Honor. Mr. Witness, just so that we understand better what you're trying to say, were there any Kikuyus in the Rift Valley?
Yeah, yes, Your Honor. During referendum time, they were there. They've been there.
How were they regarded by the Kalenjins?
When there is no election communities tend to live peacefully. But during any election period, particularly election that puts Kikuyus and other and Kalenjins on different sides, there is likelihood Kikuyus are going to be threatened to leave Rift Valley if they don't fought the way leaders from Rift Valley would like.
Just so that we're clear, line 65(6), and just correct me if I'm wrong, but you say that they're going to be threatened to leave Rift Valley if they don't have, it says here fought. Is it fought or vote? Which one is it?
Vote. Vote.
Thank you for that clarification. So if have
and
vote.
Also on the previous page, line 8, the missing word there, I believe, is us. And line 18 wasn't the witness, it was me.
Grateful, Your Honor. Mr. Witness, let's just come back now to the 2005 referendum. What were the Kalenjins fearing at that point during the 2005 referendum?
There are many issues that Kalenjins had in mind. Apart from land, it so happened that when Kibaki took over, there was a talk in the sense that Kalenjins lost jobs, lost government jobs. That was also another major issue. And during referendum, they wanted to settle scores with the government of Kibaki in the sense that the government badged many Kalenjins who are occupying senior position in the government jobs.
Just for clarification again, Mr. Witness, you said in the sense that the government budged, this is what I have on the record, many Kalenjins. Is that the word you used, budged?
Purged. Witness, don't be discouraged. This happens when there's a new witness sitting on the stand. The court reporters would need to get used to how the person pronounced things. It happens to me. It might interest you to note. The witness said purged.
Most grateful, Your Honor. Mr. Witness, when you are mentioning this land issue and the Kalenjin fears, who were they fearing was going to take away their land? What ethnic group?
Kikuyus, basically.
Why?
The reason is political.
Can you just explain to that a little bit more to us?
Since it happens every other time when we have election, other than the election of 2002, which was a bit different, to me, it's a political ploy to have an issue that people fear. It's a political way of bringing people together over an issue they fear most, and that is losing land.
You spoke about the politicians' role. Can you tell us about what type of language was being used by politicians during the 2005 referendum?
Kenyan politicians has a tradition of using hate speech during elections. During this referendum, you you could hear words such as madoa-doa. You could hear words such as kwekwe, referring to communities who live among a community that they don't want them.
Your Honors, if we could go into a private session, 5 to 10 minutes, please.
Private session.
That's the much I can remember.
We are speaking about Nandi Hills, from what I understand, or is...
Nandi Hills and Kapsabet.
Now, you've mentioned the name of Musalia Mudavadi. Can you tell us who he is, who this person is?
Musalia Mudavadi is a prominent politician from Western Province. He comes from the Luhya community. He was once the Vice President of Kenya during Moi's tenure